Yeah, we've met.
Yeah, to become a head governor's office.
Right. It's been a while. It's good to see you.
This season, he's doing policy kind of stuff. He's the numbers man that makes everything we do make sense.
Sure. Well, I remember seeing the announcement about y'all, so that's great. All right. So we ready, Vicki? All right. Let's see if we got anything there. We don't. All right, I want to welcome everybody to the training, the two of you who are sitting in here and about the 40 we've got appearing online to the July training session. We had to cancel in April, so that's probably why we've got a large number appearing online, but we're glad that you're here. For those of you who are appearing online, there's a number for you to fax or to text rather any questions you may have that arise through the course of this presentation, which should take a little bit less than an hour. What we will do is save up the questions that we receive via text until the end of the session to answer those all at the same time. Of course, if you have any technical issues as you attempt to view this webinar, then let us know that by text as well. Yeah. Yeah. All right, first of all, I'm Tom Albritton. I'm the Director of the State Ethics Commission, and this is training for lobbyists. If you're attending by webinar, text your questions to this number behind me. Give everybody plenty of opportunity to write that down if you don't have it already. And what I want to tell you is that this today will just be a general overview of the ethics laws, and it's certainly not meant to be all-encompassing. You may have further questions after today as cases may arise, and if you do, what I recommend that you do is talk to Vicki Manning in our office about anything having to do with your registration or any issues you've got about disclosure, or really just anything else you've got about any questions you may have about the ethics laws. You can direct them to Vicki first, and then Vicki will, of course, direct the appropriate questions to the appropriate department within the commission to answer them for you. What we give you today is the floor. It's certainly not the ceiling for ethical conduct. You can go above and beyond these minimum requirements. And also remember that nothing we tell you here today is a formal opinion that would give you any kind of protection from prosecution. Only a formal advisory opinion can do that, and we will tell you about that process as we go through today. Our commission is made up of 5 individuals. I am not the Ethics Commission. I am employed by the commission. The commissioners are 5 individuals who are appointed by the governor, lieutenant governor, and speaker of the House to serve staggered 5-year terms. Every year somebody's rolling off, every year somebody's coming on, so the membership is constantly changing. They are not compensated for their service, and they do serve 5-year terms. And 5 years passes quickly as I look at this first picture and realize that Judge Price has one more meeting before he rolls off. It seems like he just came on the commission. But Judge Charles Price is our chairman. He's a retired circuit judge here in Montgomery. We have John Plunk, who is a lawyer in Athens, Alabama. We have Lynn Stewart, former Chief Justice of the Alabama Supreme Court, who sits on the commission. Stan McDonald, who is a lawyer in Huntsville, Alabama. He is our newest appointee to the commission. And we will have a new commissioner coming on for our October meeting, and that's General Ed Crowell. He was previously on the commission. In fact, he was one of the commissioners who hired me. So things do tend to stay the same, I guess, even when they change. But we're really excited to have General Crowell coming back on the commission. Any of you who may work with the legislature at all, his wife is Ernestine. She's the one who will scream at you at the House floor when you walk in, usually asking if you've brought her some bait items. So I recommend that you do that if you have to be on the House floor, because she is the person to know. Anyway, she is the spouse of General Crowell. The commission, one of its chief functions is to give advice, and we can do that in one of 2 ways. We can either do it through our informal opinion process or through our formal opinion process. By and large, the most opinions we give are informal opinions. We give over 1,000 of those a year, and they are on questions involving the ethics laws, but they span all chapters of it. What we usually get from y'all, from lobbyists and from principals, are questions related to disclosure and technical questions about how to comply with registration. those questions should be directed to Vicki. Vicki will be able to answer the bulk of those. If you have specific legal questions about whether somebody is a lobbyist, that is a question that would come to legal. We don't get a lot of requests for formal advisory opinions from lobbyists, although you can certainly request one if the occasion presents itself. More often than not, when we have had a formal advisory opinion come from a lobbyist, it is to ask the question of whether they are a lobbyist. It may be an individual who is doing grassroots lobbying, or a company that has individuals out there talking about legislation generally, but not interacting with the legislature specifically about issues. And so they have asked us questions about whether that conduct qualifies as lobbying. Generally, that kind of thing does not, absent actual contact with the policymakers. However, there are some advisory opinions out there. The key difference between the two: an informal opinion does not give you legal protection from prosecution. Now, an informal opinion is the staff's best guess at what the answer is. It's an educated guess. It's generally based on either the language of the statute itself, or it is based on an advisory opinion we previously issued on the topic. So we can access that advisory opinion and we can say, in advisory opinion 2015-01, we already answered that question and here it is. If we're venturing into new territory, that's a question we're going to want to answer through a formal advisory opinion, which does give you protection from prosecution. So if somebody were to say, we are part of a group of principals and lobbyists putting on this event, and we need to know whether we can split our expenses between our groups. That was a question that the BCA specifically asked 2 years ago that we answered for them in an opinion about how to divvy up and disclose those expenses. So that was asked in a formal advisory opinion. The value of that, and what we like about formal advisory opinions, not only that it gives you protection from prosecution when you rely on the opinion as it's given to you and you gave us the right facts, et cetera, but also it gives notice to everybody else out there what the answer is. So when we were asked the question about how to disclose expenses for these events, it was nice to be able to tell all principals and all lobbyists at the same time through a formal advisory opinion, this is how you disclose. So that's another way that we do that. Now, if you don't know whether you need a formal advisory opinion or an informal opinion, you can ask us and we will tell you either we haven't answered it, so you need a formal opinion, or this is a pretty easy grab and we can go ahead and answer it for you. But the key is to have dialogue with us, whoever you're comfortable with at the commission, about the question. So if you want to go to Vicki first and you want to have the discussions with Vicki, and many people do, go to Vicki first. If you want to talk to Cynthia as the general counsel, do that, or if you want to call me directly, you can call me. It really doesn't matter. But eventually we're going to have to get your question in writing by administrative rule. We can't answer your question just on the fly over the phone. We've got to have it in writing, your question and our answer. So any questions about the informal opinion process or the formal advisory opinion process? Okay, well, if you do get any, either now or later, just feel free to ask. Need to talk a little bit about the complaint process. Our function as a commission is both to advise as to the parameters of the ethics law and also to enforce the ethics laws through our complaint process. So if there's a violation of the ethics laws, a complaint can be filed with us. We assign cases that state a violation of our act and that are supported by credible and verifiable evidence to our commissioners to weigh the evidence and determine whether it is more likely than not that there's been a violation of the act. If they find that it's more likely than not that there has been a violation, then what they will do is refer that case for prosecution either to the Attorney General's office or to the local district attorney. Okay, we have a staff of 14 people. All of those people are involved in the complaint process to a certain extent at some point. Okay, so all these disclosures that are filed in our office, sometimes those are involved in investigations we've got in our office. We've got 5 investigators who are spread out over the state, and they actually are the ones who do the bulk of the investigating. General counsel and our assistant general counsel also are involved in that, and then I do that too. We're all reviewing these complaints as they come in. and as we process them. The statute of limitations for violations of our act is 4 years if it's an intentional act, or 2 years if it's something else. Punishment is as a Class B felony for intentional violations, which is punishable by between 2 and 20 years in prison. Everything else is a criminal misdemeanor. We do have the ability to issue fines, and we can fine up to $6,000 per violation. Now, what you two need to know, the two who are sitting in here, probably 85% of what we've got in our office involves your folks. Okay, it involves municipalities and or counties. But really, with counties and municipalities working so closely together, many times we have joint issues with them. So most of this is going to be applying to your people. I will also tell you that most of your folks are doing it right. They want to comply. They're really good about calling. We've got good, close relationships with them, as we do with the league. And we're more than happy to help y'all out if you need us to, whether it's to come speak or to go into the municipalities that are members of the league and do training. We will do that too, and have done it many, many times. So use us as a resource. We would love to help y'all out with that. So all you got to do is ask about that. But also, most of our complaints come out. When they come out of your folks. And they tend to be rather low-level violations. Use of office for personal gain, which is the chief prohibition under our act. You can have a city employee who is using his or her access to money, credit cards, equipment, and using it in some way that's going to benefit themselves personally or their family or some business they're associated with. So that's generally what we do, and that's generally what we investigate. The opinion process ideally comes before the complaint process, and we try to tell people whenever we speak to them, just ask the question ahead of time so that you can stay out of trouble and so we don't have to get to the complaint process. So when y'all speak to your folks, remind them of that, and it would be a big help. Just to let us know if they've got questions, and we'll be happy to walk them through it. We don't want to see them in the complaint process. Any questions about complaints? We have to finish our investigations within 180 days of the date we receive them. My investigators have a ton of work to do, and so we can get an additional extension of 180 days if our commissioners approve it. So the most that a complaint would be pending with us is 360 days. Okay. Overall theme of the act, as I said, is that a public employee or a public official cannot use their official position for personal gain for themselves, their family, or business they're associated with. So if you're a member of a city council in town A of Alabama, you cannot vote on something that will provide a direct and unique benefit to your family, yourself, or a business you're associated with. If there's a zoning ordinance that is pending that only is going to affect your property, then as a city council member, you cannot vote on that. If you have got, as an elected official, your spouse or a child of yours or your sibling or your in-laws or your parents wanting to come work for the city, you can't vote on that to bring them in as an employee because that's using your office for personal gain. Most of the questions we get out of cities have to do with voting and voting on official matters that will affect them, their family, or their businesses. Often they will have a question about a measure that may benefit their family among a bunch of other people too, a much larger group, maybe everybody in the town, and they'll ask us questions about that too. So this idea of use of office or personal gain can come up, but there are degrees to which official action does not cross over into that. So that's why anytime there's a question about a measure and whether somebody can vote or take an official position and encourage others, that's a question to ask us ahead of time. Now, within the Act, this prohibition on use of office or personal gain has several sections that are specific that they can't use. You can't use equipment. You can't order your subordinates to go do personal items for you because official personnel are also resources. All of the equipment in the office, including your automobile or copy machine, that sort of thing. All of that, those are resources that the public gives you that they can't use for personal gain. We back on? Yep. For lobbyists, what you need to realize is that there are sections that are specific to lobbyists, and also for the person or the business that retains the lobbyist's services. That entity or that person is known as a principal. Well, I'm not doing anything. Okay. Lobbyists and principals cannot give a thing of value to a public official or a member of their family, or a public employee or a member of their family. Now, a thing of value is defined as anything that has
Yep.
Thank you. Okay, can everybody hear me okay? All right, good. In this prohibition about giving a thing of value, the definition is a gift, service, benefit, favor, and it is a very broad definition. Day in and day out, what is going to be a thing of value that you should be primarily concerned about is anything that has a dollar figure that you can attach to it. Okay, that's the easiest way to describe it, even though the definition is very broad, and there are scenarios that could include things that don't have a price tag on it. From what I've seen, what you're really worried about is taking them out to dinner. If you've got a conference and you're going to comp certain items, you're going to comp registration, you're going to comp rooms, travel, maybe some hospitality events, all of that. There are 18 exceptions to the definition of thing of value that include all of those things I just mentioned as being exceptions to the definition of thing of value, and therefore allowed to be given. So if you've got a conference, economic development function is one of them, as you well know, Brian, but if you've got one of these functions, you can ask us ahead of time to pre-certify that event. Before this summer came, we did it all the time because everybody was taking folks to the beach, and this was kind of the season for these conferences. I think we have pre-certified 2 events maybe for this summer. Folks are doing a lot of virtual events now, and I have been asked the question about the exceptions to the definition of thing of value for virtual events too. What I have told people, and it's only come up a couple of times, and the only items being offered, I think, were of de minimis value. I think they were giving them, I don't know, some kind of perk to something. Anyway, it was less than $25. And what I have told people is that a virtual event is an event, and so the same exceptions would apply to a virtual event that would apply otherwise, but you've just got to ask us, and if you want us to pre-certify the virtual event, we'll be glad to do it. I think we're going to get through this period, and people are going to still use a lot of virtual stuff. So if you have a weird scenario come up and you were wondering whether something you're offering falls within one of the exceptions, please ask us about that, and ask us if you want it pre-certified, and we'll be happy to take a look at that. But I don't think virtual is going to go away completely. But in my personal view, a virtual event is an event as any other one. So we would just look at what's being given within the context of the virtual event and see if it qualifies. For those of you who are on a webinar and may not know what pre-certification is, pre-certification is a process whereby I, as the director, can look at the event itself, see whether it qualifies within the exceptions to the things that you can give and offer to public officials. And if it is, then I can put a stamp on it and it says it's pre-certified. And that itself is an exception to the definition of thing of value. So What that looks like is usually you have conference A, the person who's the main sponsor for it will ask us to pre-certify it. And then what I will do is ask you questions about it, what's being offered, who's being invited to it, make sure that all that fits within the statutory exception, and then I'll put a stamp on it. Once I do that, I will put that on our website, so it drops into a calendar where all of the events that have been pre-certified can be viewed, and the documents supporting that event can be viewed, and everybody can see what's going on. The drop down is actually, I think, a benefit to y'all who are wanting to get events pre-certified for a couple of reasons. One, it gives you a good indication of what we have asked and what we have approved, and it also has a calendar where you can see where there are other conflicts. So you can look at it and say, well, Manufacturer Alabama has that reception on Thursday. We don't want to plan it for that. And it, I think, helps kind of coordinate all of that. Not that it may not matter to you, but just know that on our website you can see what everybody else is doing and what we have officially decided, and so it's there for you to look at. You don't have to go through any special window. There's just a pre-certification drop down. So anyway, remember that as you move through if we have a special session, or through the general session, or through the seasons where you may want to have events, or you may want to offer things to public officials, like taking them out to dinner, to ask us ahead of time if you have a question about whether it's allowed or not. You don't have to ask our permission before you do any of this, but it is a service that we provide to you. Now, as a lobbyist, you do have a $25 per meal allowance with an annual cap of $150, and your principal has a $50 per occasion with a $250 annual cap on that. So there's a separate meal exception that's over and above what may be given as part of an educational function, like your standard convention. So, any questions about that? I think most people are fairly comfortable with what the exceptions are because they're used so frequently. And they're also recognized. If anybody who is attending by webinar does work in other states or at the federal level, what we do here mirrors a lot of what happens at the federal level and also in other states. I mean, it's really not anything that we just made up that is unique to Alabama. It finds some expression in either federal ethics or in other states. We all pretty much do about the same thing within certain degrees. So if you have bumped into it in another state, run that by us too, because chances are we take a similar approach. So any questions before I move on? Okay. The other thing to remember is that if you do spend on a public official or a member of their household, and what you spend exceeds $250 in a 24-hour period, even if it is something that is pre-certified, that's still got to be disclosed. Okay, and you disclose that in your quarterly disclosures to Vicki. So the opinion that we gave to the Business Council back in 2018 really was asking that question about the expenditures that exceeded $250. Because if you think about where a lot of these educational functions are held, I mean, the room itself is coming up close to $250, and then when you throw in food and everything else, there's cumulative more than $250 in a 24-hour period that's been given. What gave rise to that opinion really was when members of the press started scrutinizing what was being spent, and they were looking at where the event was being held, and so they were starting asking questions about why it wasn't being disclosed, because the room itself is over $250. Why isn't that being disclosed? So that generated a discussion, and there were good explanations for why that wasn't being disclosed. Some people did need to amend, but a lot of people had not either covered it, or there were various other explanations for why it did not exceed $250. So rather than just kind of fumble around about it, we requested the Business Council to ask, and they did, and so gave an opinion that I think seems to be working okay. If it stops working, let us know that, because things do change out there. So if that method of accounting doesn't work anymore, you just need to let us know. But that opinion, 2018-01, has a lot of information in it, and I would recommend that you look at it, because it talks a lot about disclosure. But anyway, even if it is an allowed expense, if it exceeds that, then you would need to disclose that. Now, as lobbyists, there's another specific provision related to you, and that is that you cannot be solicited for anything other than a campaign contribution. And anything in the code means anything, because it says you can't be asked for anything whether it's a thing of value or not. Y'all can't be asked for anything. So if you're asked for sponsorships, sometimes we've had questions come up about that. If you would like to discuss that with us, if anybody requests that of you, then we will be happy to talk about it with you at that time. But you will notice in some of our advisory opinions, when we are talking about what you can and can't do, or what other groups can offer and what public officials can solicit or receive, we will often throw in, but a lobbyist can only be solicited for a campaign contribution. And that's where that comes from. It's probably the clearest section of our act. And people have heartburn about it all the time, as we get a fair number of questions about that. But you'll see that expression come up in our advisory opinions. If it's less than $25, that qualifies as de minimis. We as a commission do have the authority to raise that based on the Consumer Price Index. We checked at the beginning of this year. I think we're up to maybe $28 now. From this. I think when it hits 30, we will likely change it if the legislature doesn't do it before then. We did also do that with our statements of economic interest for anybody who may be interested, but it used to be 75 and we raised it to 81,000 this year. So if we can do it, we'll do it, but we would prefer on this not to do it unless it's a $5 increment. It just seems to make more sense doing that. But anything under $25 is an exception to the general prohibition I just explained to you. That's a $50 cap annually with that. So how I've seen this come up and how people have used it is if they're having an event at the State House during the session and somebody may want to be displaying or talking to them about, I'm trying to stay away from saying broadband, but something like that. And then they'll have, I don't know, some little promotional thumb drive that they want to give them. And it's got a value of less than $25. And they've used it for that. Sometimes you will have small items that may or may not be promotional, but nonetheless have very little value to them that people will want to qualify with this. It's just a token gift that is part of a larger event, and it's really all that they're offering. But this $25 cutoff is something you hear a lot of people talk about, and it is for this reason, that if it's below $25, then it's kind of presumed to be good, and it's an exception to the definition of thing of value, as long as you're not trying to, bribe somebody for $20, which is theoretically possible. It has happened in some corners before. But absent that intent, I think you're all going to be good. All right, and at this time I'm going to turn it over to our General Counsel, Cynthia, who will discuss in more detail a lot of these issues that I've just talked about and also some additional ones.
I hope you're all well. Tom covered some of what I'm going to discuss about pre-certifications. I'm just going to give you some more specifics. So it all is relating back to the definition of a thing of value. So the prohibition against public officials and public employees receiving a thing of value from a principal, or a lobbyist. So he talked about what the definition is, and it's pretty broad, but generally it would generally be something you can assign a value to, which favor is in there. But I mean, if you could assign, somebody moving your house, that would be a favor. You can assign a dollar amount to how much it would cost you to move your house. But so he said that he talked about the 18 exceptions. Widely attended event is an exception. Economic development is an exception. Educational function is an exception. As a separate exception is the pre-certification, okay? But typically what we pre-certify is either a widely attended event, educational function, or economic development function. So what is a widely attended event? It's defined in our code. I don't have to read it all to you, but it's essentially where at least 12 or more people get together, are expected to attend, and they have diverse views. Well, a diversity of views. That could be, you can have 18 accountants in a room and they would still be considered to have a diversity of views even if they're all accountants. Okay, so a widely attended event is a pretty broad. And widely attended events can occur outside of the state of Alabama. Okay, and a widely attended event can also be an educational function, but educational functions must all happen in the state of Alabama. So, all right, so an educational function is pretty much what you would think it would be. A seminar, a conference, it's around a formal program or agenda with educational speeches, debates, panel discussions. It's not just a social event. You have to have some sort of educational component. Economic development function is what you'd think it is, okay? Reasonably necessary for economic development. Transportation and lodging, that you can pay for transportation and lodging for a widely attended event and an educational function, and you can include spouses in that. It's not so for the economic development, but it is true for the widely attended event and educational function. So actual and necessary expenses, okay? If a conference is 3 days and it's not necessary for somebody to stay an extra 2 days at the conference, those are not actual and necessary expenses, right? So they have to have meaningful participation. So if we were invited to go speak at a conference, and my speaking at the conference would be actual participation, all right? Economic development, as I said, spouses are not included, but it's actual and necessary expenses to facilitate their participation. So the hospitality exception. You can provide hospitality that is an integral part of the event, and we'll talk about what integral part means, but it can't be a standalone event that you just have, it has to qualify as at least a widely attended event or educational function, right? You can have a reception that qualifies as a widely attended event, but you have to go down the checklist. So the hospitality is food and beverages, luncheon, banquet, reception, etc. And spouses can be included in this as well for all three, including economic development. Tom touched on this, but you can take out a public official or a public employee if you're a lobbyist and spend $25 on them. If you're a principal, $50 at a time. Aggregate for the year would be only $150 and $250. So this is the pre-certification. As I said, it's an independent exception to the definition of a thing of value. There's a checklist. I'm not going to read it to you, but this is essentially taking the language of the statute out, and it has to be all of these things in order to qualify as an educational function. Same thing with the widely attended event. It's a gathering, dinner, reception of mutual interest to a number of parties, and at least it's expected that more than 12 individuals will attend. You can't invite 12 people exactly and expect that all of them are going to attend. So typically that's not an issue. Where is it's over there. Okay, it can't be purely social. You cannot just go on a deep sea fishing trip or a hunting trip. That's not a widely attended event. It can't be purely social, and we have an advisory opinion that addresses that. These are the things we need to know for a widely attended event. The list of the invitees, and we will ask you for that list, and we will publish it. It's not a bad thing. It's about transparency and people knowing who's getting invited to these events. So if the event is under 50 people, we're going to ask for a sign-in sheet and how many people you expect to attend. And then you got to tell us what you're paying for everybody. Actual and necessary transportation, what type of transportation and what lodging. Are you putting them up at, are you having the function at a Holiday Inn and you're putting somebody up at at the Hilton? Is it that we're going to want to know the difference in maybe the place of the event and where they're being given a hotel room, and what kind of transportation is it. Are you waiving their registration fees and similar costs, which is typical, and are they a public official, public employee, or a spouse? This remote's not really working all that well. Okay, so what are they doing? You've got to tell us how they're participating, what their function is at the event. These are both for widely attended event and an educational function. They've got to either be a speaker or a panel participant presenting information related to their agency, performing a ceremonial function that's commensurate with their position, and it's appropriate for the representation of their official duties. Okay. Okay. As I said, it has to be an integral part. It can't be standalone, independent. It's got to be in conjunction with the event. All attendees are invited and sanctioned by sponsors of the event. Okay. So, like the opening reception at night, there's a bar or food or snacks or something, and everybody comes to that. That's an integral part, and that's a hospitality exception. You have to ask more than 10 days in advance for a pre-certification, and we can't give it if it's not more than 10 days. There's an administrative rule about that. It doesn't mean that the event can't happen, and it doesn't mean that it's not an exception to the thing of value. It just means that you don't have our pre-certification. Okay, there's some people who have events that they are comfortable, their lawyer is comfortable saying this satisfies an exception, and that's okay. But there are also public officials that call us in advance, not this summer, because I laughed out loud when he said we had 2 pre-certifications this year. That is pretty remarkable. But there'll be public officials that'll call or look on the website and say, hey, is this pre-certified? I'm not going, because it makes them feel more comfortable. All right, so this is our website where you can find the pre-certs. And, okay, so you can't stack, okay? These are advisory opinions relating to the spending of money by lobbyists and principals on public officials and public employees. If the 2 people in the room didn't happen to work for the same agency, but if you were both going to lunch with a public official, you can't both spend $25 on that public official at lunch. The public official is only going to get a $25 meal out of the gig, even out of the event. So, and that's true even if you're not lobbying for the same, the same cause. Okay, I don't know how often that happens that 2 different lobbyists go with a public official, but nonetheless, you can't stack. So, public official, public employee, I'm only going to get $25 meal. A public official is only going to get a $50 meal, and that's for that event. Okay, de minimis lobbying, that doesn't exist. If you're lobbying in the state of Alabama, you have to register. It doesn't matter if you're doing a lot of lobbying or a little lobbying. As I said earlier, this is the opinion that the commission determined that you cannot have a standalone event that is simply recreational and sporting, that it's not an integral part of a widely attended event or educational function. That's not permissible. So this is the same thing we were talking about earlier, that the conference ending, it's not, there's no other activities going on in the conference at the time. Conference attendees are invited. It's a dinner at the close of a day, or maybe a breakfast at the beginning of the day. That's permissible. This is the opinion that Tom was referring to, that you can aggregate expenses. So you have multiple sponsors, and a sponsor, each one gives $1,000, but this $1,000 is spent on food, this $1,000 is spent on hotel rooms, but you've got to designate who the sponsors are and what their contribution is. And if you spend more than $250 on a public official in a day, you have to report that in the 24 hours. So it reaffirms that as well. And we're going to ask you who the sponsors are at the time of this pre-certification. Okay, this is an opinion asked. We have what we call executive branch lobbying is 1.1. Well, if you're selling, there's an exception to lobbying that says if you're selling goods and services to the government, then it's not lobbying. But then we have and that's in 3625.1, our definition section. But in 1.1, it very specifically says that if you are doing that with the state government, then that does make you a lobbyist and you must register. Okay. So Al's question was, if an independent contractor is marketing their garbage collection services to, I guess it was a local city council or commission. If he's seeking local, I don't know if it was specified which one, but if it's a county or local contract, they don't have to register. Okay. Any questions about that from the two of you here? Okay. This is our website. This slide is obviously old. We've moved on from the 2015 fines for SEI filers. But nonetheless, our website actually has a lot of really good information in it. If you ever get there and see something that is not accurate or you want more information in it, please let us know because we can actually update this pretty easily. And we want it to be as user-friendly as possible. Okay, do you want to do parting thoughts? You want me to?
I'll do it.
Okay.
We're doing candidate qualifications for municipal elections, and we've got to certify these within 5 days. So this stack has to be done by the end of the day.
Yeah, that's why we're.
Just my stack.
Yes, and my stack is over here.
So give me just a second. 7th, on the 30th, and he does live at Waterloo. Okay.
It's a very complicated process.
Yeah, sometimes we feel like we're cooking and washing all the dishes too. Okay, so for final thoughts, this is just kind of a bullet list of things that you as lobbyists need to keep in mind with this. Remember to update your registration within 10 days. If your representation changes, you take on somebody new and you need to update it, do it within 10 days, and you do that with Vicki Manning. Communicate with your principal. Many of the problems that we've got in our office from a registration standpoint come from the lobbyist and the principal not talking. Often what we're waiting on is for the principal to confirm that you are in fact their lobbyist, and that will hold up the registration until they do confirm it. So during the session before, we have had other lobbyists call over and say, so-and-so's over here lobbying and they haven't registered. More often than not, what that is a lobbyist who has registered, but the principal hasn't confirmed that that person is actually lobbying for them, so our website doesn't reflect that they have registered. So what that means is that Vicki then has to get on the phone with the principal and say, your lobbyist is being harassed. You need to confirm that they are in fact your lobbyist. So if you could have that discussion with them ahead of time, it would make your job a lot easier. When you file your quarterly filings, review them yourself if it has your signature on it. We have often also had problems where people have filed inaccurate disclosures that have somehow been brought to light by somebody, and it was when the lobbyist didn't review closely what was being filed. So it's just a tip. Review it. If it's got your signature on it, make sure that it is correct and accurate. If you aren't sure whether it's got to be disclosed, ask us. Remember the 10-day rule for pre-certifications. We've got this up here because for a long time there was not a requirement. In 2015 when I came on, we put that in an administrative rule that you had to have 10 days notice before we could pre-certify. Most people get that now, but the last thing I want to do is have to deny it because it violates the administrative rule. So remember, 10 days, 10 days, 10 days. And if you email it to me, if you text it to me, all of that gets you in under the wire. And you've got until midnight, okay? So and we do keep it pretty wide open for you. Just get the request to us. I've had somebody call me at 10 o'clock at night before and say, the 10 days is running. This is like the day. What do I do? And I have said, just text it to me. I will convert that into an email. I will send it to myself, and that will be your request. So it's not magic, and it doesn't have to be very formal, but we've just got to have just written confirmation of what it is you're wanting to do within 10 days. And if we have to follow up with you and ask you more details, we'll do it. And again, if you forget everything that I have told you today, just remember the one person to call is Vicki Manning, and she will get it to the right person. So do the two of you have any questions before we leave? Okay. Anybody on attending by webinar, did they submit any questions?
I don't have any.
Okay.